Quick introduction. I am Victoria. I'm one of the Koppenberger Law Firm's estate planning attorneys, and I am joined today by Charles Sosa. He is the CEO of Lifestyle Financial Services. So we are very happy to have you guys with us today. I've been with the Koppenberger firm for just over 3 years now, working primarily in our Northern California offices. Charles, do you want to say a quick word?
Yeah, it's a pleasure to be with everyone here today, and thanks for joining us. I've been with Lifestyle Financial for about 14 years and just really enjoying it. Obviously, when the markets are a little bit more cooperative, it's a little bit more fun, but challenging seas make good sailors. So I look forward to getting into this a little bit more in just a few minutes.
Perfect. All right, well, we can go ahead and get started. All right, so like I mentioned, we're going to be covering quite a bit today. So we're going to hit some of just the estate planning fundamentals. So for those of you who either have never experienced estate planning or you have just a basic understanding, this will be a really good crash course for you. For those of you who do understand estate planning, it'll be a good reminder of why the documents you have are so important. We're also going to go through funding your estate plan and investing in your estate plan. So like Charles mentioned, right now the market is definitely a little bit all over the place. And so it's really important to understand how that works with an estate plan and how the investments and estate planning side of things work together. We're also going to touch on the so fun topic that is taxes. So a lot of people are very interested to know, how do you protect your estate from taxation? How do you reduce it or completely eliminate it? And then one of the reasons our firm was actually founded is based on the fact that everybody has a legacy and that legacy matters. But a lot of people don't fully understand what that legacy can entail or how to leave one. And so we're going to go through that at the end as well. So jumping into your fundamentals. So this first document is one that if you're over the age of 18, you just need to have one in place, period. The reason is your healthcare directive is there so that in the event you became unable to speak to a doctor or communicate your wishes to a doctor, you have it in writing who can take care of you and what some of the decisions you would want made are. This does quite a few things. For one, it protects you if you are medically vulnerable. So it ensures that you have someone who can be your advocate and who can do so on your behalf. But it is also there so that they don't have to guess at what you would want. One of the greatest gifts you can give the person who is in charge of your medical decisions, if you can't be, is guidelines for what you would want or actual answers for the questions that they may be asked. This can relieve a lot of stress, guilt, and even just pressure and confusion that can come from serving as somebody's healthcare power of attorney. So again, if you're over 18 and you do not have one, absolutely get started on yours now. And if you do have one, it's wise to get these reviewed every 5 years or less. The reason is not that something will have changed, but it's good to make sure it hasn't changed. What I mean by that is you're making sure the person you've named is still who you want and that the decisions you originally made are still correct for you today. Now, the next document that, again, if you're over 18, you really should just have this in place is your financial power of attorney. It's in the name, it's dealing with finances. So this is where if, again, you could no longer manage your own finances or estate, you have put in writing who can do so on your behalf. This is unfortunately a bigger and bigger issue for people where they've had a stroke or they have Alzheimer's or dementia, because you need to have in place then who can actually take care of you and use your finances to take care of you. So this is again where we work with someone like Charles to make sure that not only do you have someone in place, but that they have someone to turn to when this time comes, because it can often be a very overwhelming job if you don't have other professionals who can help step in and guide you. So this is another one that we recommend you get reviewed every 5 years. Again, we may tell you everything is completely fine and you walk out the door with peace of mind, but in other cases, we catch that the person you'd originally named may not be appropriate anymore, or the document may be out of date for what the law can do today. So if your financial power of attorney is older than 5 years, I do recommend you come in and get it looked at so that we can make sure it is still legally effective. Now, these documents I've already mentioned are important, but one of the other reasons they're vitally important is because if you do not have these in place, what is called a conservatorship may be required. Basically, a conservator is someone who's appointed by the court to do exactly what those two documents would have told them to do anyways. And so if you don't have those documents in place, naming who and then what, the court is going to have to do that because you need someone who can then legally be put in place because they weren't prior or they were not formally done. So your conservator would essentially oversee your finances, establish and monitor any physical care you need, manage your living arrangements, again, doing everything that those two documents would have done anyways. Conservatorships are very time consuming and frankly, they are also very expensive. The other issue right now is, especially in light of COVID, it is very hard to get a conservatorship hearing in a quick amount of time. And so one of the frankly very sad things we're seeing right now is people need a conservatorship. We get a call, my loved one needs to be taken care of. They didn't have documents in place. What can I do? And we say, okay, the court to grant you the power to act as their conservator. We file all the papers. That takes us about a month because we have to gather all the information. The client has to do certain things. Sometimes it takes longer than a month, depending on how complicated the situation may be. We file it and we don't get a hearing date for 6 months. And the problem then is that this person is sitting there vulnerable up until someone is appointed to take care of them. And so again, this is all avoidable by setting up just those two documents I just went over. Now, one of the big things we work with here are wills and trusts. And a lot of times people are confused because these words are used very interchangeably. So a lot of times if you're watching something in Hollywood, they reference a will almost each time. A trust is almost never mentioned. And so it gets confusing on why do I need a trust or when do I need a will? And so we're going to clarify that right now. So you would need a will, and a will would be protective enough for you if you were someone with no real estate, so no pieces of property, if you had an estate less than $184,500, and or you were the parent of a minor child. Now, if you have minor children, you just need a will no matter if those other two categories apply or not. And the reason is the will is where you actually name guardians to take care of your minor child if something, God forbid, happened to you before they reached 18 years old. But if you fall under those other two categories, then a will may very well be exactly what you need. The problem is a lot of people think, again, all they need is a will. They've never heard of trusts, and so they get a will set up. They come to us thinking everything's fine, and we say, oh, you actually are not adequately protected. And they ask us why. Well, the reason you are not adequately protected with a will, if you have real property or an estate greater than that $184,000 number, is because then your estate, when you passed away, would be subject to what is called probate. Now, probate is a court process that is essentially there to settle the accounts with the living and to settle the accounts of the one who's passed away. What that means is if someone passed away and there was a mortgage on a house or they had outstanding bills, anything like that, those things would then have to be taken care of in court if all they had was a will. And then ultimately, the court's job is to transfer the title to your heirs or beneficiaries. What that means is who ultimately gets your assets is also dealt with in court. Now, I mentioned this already, but probate is a legal process that follows state rules, which if you have ever dealt with the government or a court, you often know that they are not known for speed and efficiency. And so what we unfortunately see with probate is the delay that it can cause can be years. So what that means is when somebody passes away, if all they had was a will and now their estate has to go into court to be settled, you are often looking at somewhere between 2 and 5 years to get everything completely wrapped up. This is extremely taxing on whoever has to deal with it, because not only are you likely grieving whoever has passed, but now you're having to deal with the court. You're having to pay quite a bit of money. You're having to have this process drawn out significantly longer than it would have needed to be. Now, I mentioned the cost is often quite large, and the reason is it often costs between 5 and 7% of the gross estate. So what that means is they're looking at the totality of your estate on the gross side of things, not necessarily what your equity was. So unfortunately, what we have seen is someone who owns a home where they only had maybe 10% equity in the home, that 5 to 7% is still put on the entire value of the home. And so this leaves less and less and less for the person or people that you would have wanted to inherit from you. So probate is definitely something that here at Koppenberger, we encourage every person to seriously try to avoid wherever possible. And how we avoid it is using a trust. So again, trusts are not often talked about when you talk to people. Will is generally the word that you're going to hear out and about. But the trust is what can actually protect you from probate. It's a contract where you are setting the contract terms and you have someone in place to carry out your wishes once you're gone. So like I mentioned with the conservatorship and the healthcare power of attorney and durable power of attorney, you can avoid a conservatorship with having those two documents in place, and you can avoid a probate by having a trust in place. So this is something, again, that we strongly encourage every person to really consider, because probate is just one of those things that if you can avoid it, you absolutely want to. Now, the settlor is who actually creates the trust and sets the terms. So if you come in and meet with us and you're setting up the trust, you will forever be known as the settlor. You are also likely going to be, excuse me, your own initial trustee. So as your own trustee, you're basically going to handle your assets and affairs exactly as you've already been doing. There's not really a tangible, noticeable difference when you set up a trust for what you can do or not. But the trustee is a role that will shift at some point. If you become incapacitated or when you pass away, you need someone in place. And often we recommend having a list of people who can serve if the first one can't. But that is someone who then manages and invests the trust assets on your behalf and who follows the trust terms and essentially takes the place of a court having to do an administration. So it would be their job once you pass away to make sure final bills are paid, your last tax return is done, and that the assets are ultimately distributed to your beneficiary. Now that beneficiary while you are alive is going to be you. But once you pass that, it will be the people or entities that you have named to actually benefit from your estate. Now, the who, as far as the trustee and beneficiary, can be more complicated conversations than some people realize. And so what we really focus on here is having those conversations to make sure that you have a customized and comprehensive estate plan. So none of our estate plans are a one size fit all. They are all very much based on your individual circumstance and situation. Now, obviously, some of the benefits I just mentioned are the fact that you can avoid the cost and delay of probate, but also it protects your privacy. So if something has to go through court, unfortunately, that does mean it becomes a public proceeding. But if you have a trust set up, everything remains private and only is seen by those you would have wanted. We are also going to talk today a lot about tax planning, and that is something that a trust can absolutely allow. And then, as you've heard a couple times now, your trust and other documents are there to avoid any court supervised guardianships or conservatorships, and ultimately to make sure that your wishes are the ones actually carried out. Now, one of the other documents you do get if you have a trust is a will. And the reason is for extra asset protection. So one of the big things with the trust is that it only protects what it owns. And so what that means is when you set up a trust, there are certain assets that actually need to go into the name of the trust. And this is something we walk through in detail with our clients individually so that they understand which of their assets need to be in the trust versus which ones don't. This pour over will is incredibly helpful because a lot of times what we have found are people forget to put some kind of asset into the trust name. And so this pour over will essentially tells a court to scoop that asset up and give it back to the trust. That way, rather than it going through a full probate, it just goes right back to your trust. So we do all of this because, again, an estate plan is not simple, but it has to be very comprehensive and custom to each individual person's needs, wishes, and wants. And with that, though, the reason we are working with Lifestyle Financial is that your assets also need to have that comprehensive and customized approach. And that is something that at Lifestyle, they absolutely do. And so I'm now going to turn it over to Charles to talk about the next couple sections.
Okay, thanks, Victoria. So I'm going to talk about funding your estate plan, and it's really important because a lot of people have this false notion or understanding that it automatically happens. And so you go through the process of creating this living trust, and then you want to make sure that all your assets are in the living trust. As Lloyd, one of the attorneys at Copeland Barger, says all the time, as soon as you create the trust documents, you go into the trust car, you drive to the trust home, you sleep in the trust bed, because all the assets are in the trust. But it is very important to make sure that your assets are incorporated and titled properly, so that way they are in your trust, because that does not happen automatically. And then there are certain strategies that can make it more efficient to fund your trust. And so the end goal is to ensure that the assets that need to be in your trust are in the trust. One of the benefits of working with Lifestyle Financial or a financial advisor that is very familiar with the estate planning process is that we understand which assets do and do not need to be in the trust, and also the types of situations where those assets might be. There might be a different situation where certain things that normally wouldn't be in a trust might be. For example, special needs planning and other things. I don't want to get too far into that, but I'll go to the next slide. And so there are certain things that don't need to be in your trust, and generally speaking, and I'm going to say generally a few times because there are very specific planning situations where you would want them. But for the most part, there are some things called beneficiary designated accounts. Now, these are accounts that generally do not need to be in the name of the trust. And so one of these is a 401k. Well, why wouldn't you want your 401k or your IRA or retirement account to be in the name of your trust? Well, one of them is because only one person can be the owner on that. By virtue of an IRA, an individual retirement account, there's only one person on that account. And then attached to it, you have beneficiaries. And so the whole point of a trust many times is to avoid probate and to ensure a smooth transition from passing, so that way your assets flow to the people you want them to in the manner you want them to. However, with IRAs and 401ks, you can attach a beneficiary. So these will not be subject to probate. However, it is important to update your beneficiaries from time to time and ensure you do have beneficiaries. Because if you do not have beneficiaries on a 401k or an IRA, one false assumption that people sometimes make is that they're automatically rolled into your trust. It doesn't happen that way. And so then you would have to go through a probate process in order to get those assets to the people you wanted to have them. And then another one is life insurance. And so with the life insurance policy, again, there are beneficiaries to that policy. And there are specific situations where a trust will be the beneficiary of a life insurance policy. But with all of these assets, regardless of which one, you do want to make sure that the beneficiaries are up to date investing in your estate. So I'm going to talk about inflation. And so I'm sure everybody's been to the gas pump recently, and we've seen prices are slightly elevated. I think that's safe to say, or the grocery store. Everything's getting more expensive right now. We're seeing inflation at the highest rate in over 40 years. And that can make it a little bit scary. And I think there are a lot of benefits to having the guidance from a financial advisor, especially in times like we're experiencing right now. And so I think the first step is to really ensure that there is a plan that takes into account the volatility of the markets, because everybody wants to buy low, sell high. Everybody wants a high return and low risk. Unfortunately, there is a little bit of a relationship. We all do have to take some degree of risk, but I think it's important just to ensure that it's calculated and that we're really analyzing your goals, objectives, and just going through that process to ensure that you're not taking on more risk than you can afford to or that you're willing to. Because the last thing you want is to be in a situation where your investment drops and then you just are unwilling to tolerate any further volatility and you move it out to cash. Investments are really about goals. Many people get into the minutia of investing and they get focused on the actual investments and the returns. But at the end of the day, we're working with people and what they're trying to accomplish. And it goes so much beyond just a number to me. And I think it's important to identify just so many different retirement goals and other things in the estate plan. But it's just really good to ensure you identify what the goal is behind a certain investment. And then is it a long-term, short-term, medium-term, how much risk, and then just ensuring that the investing is done with the right plan in place and that the plan is regularly updated, because it's not a set it and forget it. We have to invest in the markets that we have, not the markets that we want, and the markets evolve over time. And so that's why it's important just to ensure that those investments are continuing to be aligned with your goals. And so that brings me to investing in your legacy. So compounding interest, I get I get really excited about compounding interest because I'd say it's the second most powerful force on earth, with the first being God. Compound interest is amazing. And so it's just the earlier you set it in motion, then the longer period of time you have to allow it to grow, the quicker and the more momentum it's going to build. And so when investments have a longer time horizon, it's going to grow faster and it's going to grow a lot quicker, especially as it gets into the later years. Also ensuring that we're dealing with tax efficient strategies. There are ways that we can invest to minimize taxes, especially when you're talking about, with trust assets. There are ways that we can take advantage of step up in basis and other things. And so generally we're going to shy away from things like annuities where it's tax deferred and you don't get that step up in basis. But again, that's more situation dependent. It's more goal dependent. But you do try to, as an advisor, I try to select investments that are going to have the most tax favorable treatment inside of a trust. So that way you can take advantage of all the tax benefits that are available to you. And then really having the legacy component too in the planning. And so over the 30-year plan, and legacy is kind of a difficult subject to breach sometimes, more topic to discuss, because we don't like thinking about legacy as much in the terms of just, we like to push it down the road. We've got plenty of time, but it's important that we plan now because that allows us to put some strategies and sometimes advanced strategies in place to minimize taxes and just allow a smooth transition. And so including investments in your estate plan. So investments are just a vehicle to transfer wealth. There's the example here for investing in Apple 20 years ago. There are so many stories, and we have lots of clients, especially in the Bay Area, who got involved in small companies like Apple and Microsoft and Google, and those companies have taken off and they have maybe a bunch of stock at a very low cost basis, and now they're looking to see how they can plan to allow the transition of that wealth to further the next generation. And it's just a vehicle of planning that's going to allow for the education of future generations. So there's lots of things that we can do when we have time to plan, and then ensuring that these investments are included in your estate plan in ways that we can, again, minimize those taxes and ensure that those assets are transferred to the people, charities, and other causes, whatever your plan states, in the most efficient way possible. College planning So not only is gas and groceries getting more expensive, but every year it seems college tuitions are increasing. Um, I've got two teenagers, and they're about a year and a half away of starting to look at going to college, and so that is very near and dear to my heart and on the front of my mind and my wallet. And it's really important to do that college planning. And when someone hears 529s, they're not just for education. There are so many other things that we can do with them. Um, UTMAs and UGMAs and uniform gift minors do allow you to get children interested and learning about the investment world. Um, my younger children, as well as my teenagers, all have UGMA accounts where I'm teaching them how the stock market works. We've been teaching them to invest. And so it can be a kind of fun transition that is going to allow that next generation to begin learning about investing. So that way, when the transition plan does occur and the next generation does come into some wealth or some investments, then they're more trained and understand how to handle it. So what's happening in the market today? So as I previously went over it, we're at the 40-year high for inflation. We've got a ton of volatility right now. And so we're just seeing, I think some of it was from COVID, and then we just have inflation across the board. Everything from building supplies, consumer goods, gasoline, energy, vehicles, everything is getting more expensive. And especially, for people on a fixed income, that's a very scary thing. Everybody, I think, is feeling the squeeze right now. And geopolitics matter because I'm sure that everyone's heard about a little conflict going on right now with Ukraine and Russia, as well as other things that are going around the globe right now with China and Taiwan. There are a lot of things and factors that influence our markets, and it's just getting more and more complex, and the world is getting smaller and smaller. And when you're talking about investments, everything is going to influence the investments. And so we're no longer in a microcosm. Even if you're investing in just US domestic stocks, they are going to be affected by swings in the international markets. It may be less than if you were investing in international directly, but indirectly, everything is related. The 60/40 model, I do want to talk about that a little bit. In the past, it worked. And basically, what that refers to is a portfolio allocation of 60% in stocks and 40% in bonds. And that was designed to provide an avenue for an appropriate amount of growth with fixed income, also referred to as bonds, helping to lower the volatility for the portfolio. This portfolio has not been doing well, this allocation. And in many ways, the 60/40 model is dead because right now we are seeing just a completely different environment in the market right now. And so what we're looking at is volatility that we haven't seen since the financial crisis, 2008, 2009. And we've seen an upward trending market. So the last 6 months have been a little bit of a shock to a lot of people because in reality, we just haven't seen volatility in more than a decade. The market's been going up and up and up. Now, volatility is normal, but it still does not detract from the shock that investors are feeling. And then bonds are having the worst start that they've had in over 30 years, especially with rising interest rates. I mean, we've seen interest rates go from sub 3%. Now they're, over 6%, especially for mortgages and everything. And so when the Fed raises interest rates, that has a negative effect on bonds. And so when you're looking at the 60/40 portfolio, the bonds are getting hit hard because of the rising interest rate environment. The stocks are getting hit hard because of the volatility, and it's not balancing itself out like it used to. And so that's why it's really important to look at your investments and to have a trusted advisor that's going through your portfolio, because not all investments are equal. Just because something is a bond does not mean it's a safety net. At the end of the day, a bond is just debt, and there are good bonds and there are bad bonds. And there are times to invest that you'll want to invest in bonds and fixed income, and times you don't. And right now, it is more difficult to find good bond funds than it has been in the past, just because of the environment that we're in. And we do have some long-term trends right now. Coming out of the pandemic, there are some supply chain issues. Still constraint supplies on a lot of things like semiconductors and other things that are slowly but surely working themselves out, but the shipping backlog hasn't improved. The cost to manufacture goods, the cost to transport goods has been skyrocketing. And the supply chains are suffering as a result. And it takes time to work that out. Right now, we're looking at possible food shortages and increased food prices, especially when you look at the Ukraine and Russia. Ukraine is the breadbasket of Europe, and so those fields with the wheat, with the war going on, it's going to be very difficult for them to be producing the wheat that they did in the past. And you can't just replace an entire country's production immediately. And so that's going to lead to higher prices, constraint supplies, and it's just going to have a trickle down effect. And that's really why there's the importance of a plan. So when you have a plan, it gives you the peace of mind, because the markets are going to get volatile, and this volatility that we're seeing, I think, is going to get worse before it gets better. And so that's why it's important to have that plan, to understand that plan, and to constantly revisit that plan to ensure it's still aligned with your goals and objectives. Because at the end of the day, nobody likes market volatility, including myself. But if you have the plan and okay, I'm not retiring for 10 years or 15 years or whatever your situation may be. We talked about this in the plan. I understand this is going to be rough, but we have taken certain steps to mitigate this, or we're taking advantage, or the companies that we're investing in are good, solid companies. I feel comfortable, because at the end of the day, we want you to feel comfortable. You should understand your investment plan, and you should understand why you're invested the way you are. Understanding market tolerance. So you want to ensure that you're not taking too much volatility in your portfolio, that you're not in a portfolio that is going to have fluctuations that you can't tolerate. Because at the end of the day, the last thing you want to do is experience a downturn in the market, decide you can't take any more fluctuations in your portfolio, move to cash or super conservative investment, only to see the market rebound 6 months, a year later, and now you've essentially secured a loss. Also ensuring that the time growth frame for your investments are appropriate. And also understanding that not all investments are going to follow the same goal and path, and everyone has different goals and objectives. And that's why it's important to have that individualized plan where your investments are aligned with your goals and objectives. Market volatility is always going to play some role in a portfolio, but when you plan actively and you try to remove the emotion and then look at it from a more objective viewpoint, it allows us to make better decisions, as opposed to just knee-jerk reaction. The market's going down, I need to pull my money out. Cryptocurrency. So understanding the definition of cryptocurrency, I think we've all heard about Bitcoin and some of these other things, and Ethereum, Dogecoin. There are new cryptocurrencies coming out every day. The government's still not quite sure how to regulate it. They're still trying to understand it. But what I will tell you is that they are very much so aware of it. As you filed your taxes last year, there was a question at the beginning of your return. Have you bought or sold any cryptocurrency? Yes or no? And so They're very aware of it. And it's very much so in its infancy right now. There are people who seem to be very strong believers of it, and there are people who uh, think it's monopoly money. And regardless of your opinion on it, it's something that we have to contend with right now, and it's something that we have to be aware of. And then ensuring that if you do hold cryptocurrency, that that is included in your estate plan, whether you have a e-wallet or a login credential or whatever it is, you're going to want to ensure that that is included in your estate plan in some way, shape, or form, and that you take the proper steps. So that way you're not like some of these people that have been publicized in these news articles when cryptocurrency was nearing its highs and they're looking for a computer drive or something where they had stored cryptocurrency, or perhaps they forgot the password for their e-wallet. So that is something that you do want to be aware of. And essentially, cryptocurrency is just generally a blockchain or a token. They're all different. They all work differently. I am by far from an expert on cryptocurrency, although I am learning more and more on it. But it is a space that has evolved so quickly. Many people don't truly fully understand how it works. And I think it's important to understand too that is a very volatile asset. Bitcoin, for example, has dropped 66% this year from its high. And so some people prefer to have some cryptocurrency exposure in their portfolio. Other people do not. That's a very personal decision. And if you have, more in-depth questions on this, I'm happy to go over it with you. It's always surprising to me how few people have a budget, how few people have a financial plan. And it's important to not only create that plan, but then work actively on implementing and updating the plan. Our sole responsibility at Left Lifestyle is to help you with that process and help you implement it. The markets are not fixed. They're always going to be changing. That's the only guarantee that I can provide you. There will be ups and there will be downs. And there are no guarantees in the market. But we specialize in the markets and we're able to do the research and the legwork for you. So that way we can educate you and help you, along with us, make the most educated decision possible. And so our job is to give you all the facts and allow you to make the decision you feel most comfortable with. Many people too don't have the time or experience to focus solely on their plan. Very few people have the capacity or the want to sit in front of a computer screen and do hours of research on the market every day. And that's where we come in. And so our commitment to you is to help keep you on track and help you achieve your financial goals.
Perfect. All right. Well, thank you for all of that. So now that he's talked about all the different ways you can build your estate and keep it and everything else, we're going to now turn more to how do you keep all of those hard-earned assets in your pocket or your family's pocket. So let's now talk taxes. So for a lot of people, taxes are not an enjoyable topic. Taxes are not normally a fun time of year for many of us, but they're incredibly important, not only in what we do on the Koppenberger side, but also what Lifestyle does. So one thing to note is that obviously during your own life, you need to be aware of filing your own income tax returns. But once someone passes away, going back to that trustee we talked about, they are going to be in charge of filing your final income tax return. But then what happens? Well, now we're going to be looking at income tax basis or property basis. We're looking at property taxes. Is there an estate tax return needed? And how do we eliminate or reduce estate taxes? So let's first look at estate taxes. So this is what happens when somebody passes. And essentially what the estate tax is looking at is what is the size of your taxable estate. So right now, if you have an estate greater than $12 million, you absolutely need to come and see us and talk about tax planning, because there are things we can do to eliminate or reduce taxes. Now, a lot of us may not be concerned about $12 million worth of asset protection. But you'll see on that bottom bullet point that there is unfortunately what is called a sunset provision, which means in 2026, that is going to drop from 12 million to somewhere between 5.5 and 6 million. And frankly, given who is in our administration right now, they would like to see that reduced closer to 3 million. So now all of a sudden, this is a fluctuating number that may now impact your estate and those investments you have, those pieces of property you may have, and you may need to come and consider advanced tax planning. But there is one other thing to be aware of, and that is called portability. Essentially, that means if you are in a if you're a married couple and one of you passes, if there is an unused portion of that $12 million, you can essentially transfer the remainder to the surviving spouse so that they can add to their own individual pool for when they pass away. Now, with portability, this is something that after someone passes has to be done relatively quickly. Typically, this needs to be done within 9 months. So unfortunately, for a lot of people, they're not thinking about portability in 9 months after somebody has passed. They've just lost a spouse. The last thing they probably want to do, frankly, is come and talk to us about how do I get their unused money into my pool. Now, that's not the case for everyone, but it is definitely something to be aware of, because again, what a lot of people don't do is deal with this within the first 9 months. Now, with that being said, one alternative, or at least a bigger safety net for portability, are advanced protection options. So one of the trusts we have is called an AB trust that essentially doubles the estate tax exemption that you are entitled to. So if you would have had the 12 million, you now get 24 million. If it drops to 3 million, you now get 6 million. I think you can see where I'm going with that. So the AB trust can absolutely be used for tax protection, but these trusts are also ideal if you have a blended family, if you're concerned about your spouse remarrying, about reducing taxes. Any of those things can also be protected in this AB trust. The reason is when one person splits in a married couple, or not splits, when one person passes in a married couple, the trust essentially splits into 2 separate parts. The survivor still has their part, it's theirs to do with as they see fit, but now there is this B trust, or decedent's trust. That trust becomes irrevocable, which means the survivor can no longer change it and they cannot give it away. So that locks in that additional 50% protection for estate taxes. It means that if the survivor remarries, they cannot give your portion away to a new family. It means that if the survivor got in a car accident and it's completely their fault, your 50% can't be taken away from them either, so that it's there if they have an issue that they can still use those funds. So these are advanced planning options that are available. Now, the ABC trust is basically the AB trust, but it adds a third pool for estate tax protection. So again, especially as that number reduces, people may start needing to look at doubling or even tripling in some cases the estate tax exemption they are entitled to. If you have any questions on this, and this is more complicated often, please do set up an appointment with us at the end of this webinar. Other ways to reduce your estate to avoid estate taxes are by charitable giving. So you can either name charities in your revocable trust and just automatically have that portion go to a charity when you pass. You can name them as beneficiaries on different accounts. So some of the ones Charles mentioned, like your 401k and IRA, you can gift to charity and have that be reduced out of your estate. And in some cases, people need to give such a large amount to reduce their estate. We actually set up what are called charitable remainder trusts that can house those assets and actually provide you an income during your lifetime, but that keeps it out of the estate tax consideration once you pass away. So there's numerous ways that charitable giving can benefit your estate, and it can benefit how you feel about things and how your family may feel. Now, there are a few other ways we can protect against taxes. So one of the things that we talk about once someone has an adult child or multiple adult children is how to protect their inheritance and how to protect your legacy down to even your grandchildren. And we do this in the form of what is called a protective lifetime trust. Essentially, this is insulating your child's inheritance from anything else trying to take it away from them. So if they get divorced, it cannot be taken from them in a divorce proceeding, but it also protects their inheritance from the IRS, bankruptcy, lawsuits, and even creditors. So if your child starts a business and in this oh so fun volatile market, it doesn't go well, they end up bankrupt, they now owe taxes, their inheritance cannot be used to be taken from them for any of these debts or liabilities. So that's a huge advantage of that kind of trust. But there's also an additional tax benefit that says when your child passes, anything left in that protective trust will go to your grandchildren free of tax. So then it's meaning that your children's estate does not have this inheritance considered. And so not only do your grandkids get it free of tax, but it's never going to be subject to an estate tax again. So now you're doing multiple generations worth of protection and planning. One of the other things that changed recently was the Secure Act. Now, again, Charles talked about IRAs and 401ks, and unfortunately, these are subject to the Secure Act. Very simply put, this is something that now, essentially, if you inherit an IRA or 401k, you have to withdraw the sum within 10 years after the person's passing. Now, for spouses, you don't need to be concerned about this, but for almost everyone else, this is a rule you need to be aware of. Not only because from a personal tax liability, this can be significant, but also as you are planning for that legacy or to leave things to beneficiaries, you may need to relook at, how do I actually invest? Where should my money be going? I know my father, when he was working, was told, you put it in an IRA, you put it in a 401k, pretty much period. And that is essentially where the vast majority of his wealth now is. The good news is he has a retirement plan, and that is fantastic. The bad news is that if there are monies left in there, that is the majority of his estate, which means I will have to withdraw those sums within 10 years, which is likely going to give significant taxes back to the government. And so I know for him, he is already working with Lifestyle to make sure that he can reduce that as much as possible without causing any penalties or detriments to him. So this is where it absolutely should trigger that you get your plan looked at, whether that's with Lifestyle or the advisor you already use. It is worth looking at, is your plan accounting for current laws? Now, another tax that is often misunderstood is what is called the gift tax. So a lot of people have heard that you can give $15,000 per year to an individual. Well, that number is now at $16,000. The other piece, though, that is involved that is often not understood is the fact that you have what is called a lifetime exclusion. So what that means is if I am gifting Charles $20,000 in a given year, I have to tell the IRS I gifted him in excess of $4,000, but I do not pay taxes on that. Instead, that $4,000 just gets deducted out of my $12 million pool. So the only way I am going to pay a tax is if I gift Charles $12 million or more. At that point, I would have an issue. He will think I'm the most generous person on the planet, but that's the only time you have a problem, is if you go over that lifetime exclusion. Now, again, keep in mind this exclusion also does fluctuate with the estate tax exemption, but this is something then that if you want to gift to kids or to schools or charities or whatever it may be, you have more options than often people know about. All right, so now what happens when you pass away? So a lot of times people are saying, well, to reduce my estate, can't I just gift? And you've just learned about the gift tax and you're saying, well, I could gift and gift and gift and gift and have no problem. And that is true in theory. The problem with gifting is twofold. One, it means you're giving it away. And so if you need it in the end, there are going to be times where you can't get it back or the person is not willing to give it back. And so gifting can have risks where you're giving it away and you cannot expect that it will ever come back to you. The other issue, though, with just gifting is the fact that you can lose out on what is called the new cost basis or just basis when somebody passes. So when someone dies, your investments and property get a step up in basis. What that means is, let's say you bought a piece of property back in 1960 for $50,000. And today, realistically, that property may be worth somewhere between $1 million and $2 million if you live in California. Well, all of a sudden, that $1 million to $2 million asset, if you sold it, could have significant capital gains ramifications. But if you are able to wait to pass it on to your children or to someone else when you pass away, it will get a new value as of your date of death. So if that property is worth $2 million in 2022 and you pass away in 2022 and they sell it for $2 million, they're not paying any capital gains on that property. So that is significant when you're looking at, what do I do? Do I gift it? Do I sell it? Do I let it be an inheritance? Now, each person's situation is going to be very unique. And so this is something where in some cases it is more appropriate to be gifting. But this is definitely a conversation you want to have before you take action so that you understand not only the tax ramifications for yourself, but also the potential ramifications for your generations after. One of the other very hot button topics right now is Proposition 19. So unfortunately, Proposition 19 drastically changed the benefits of inheriting property. So essentially, what it changed is that the only residence that even can qualify to keep your property tax basis when you pass away is your primary residence, but it has to be considered the primary residence of your child after they inherit it. So unfortunately, that means if you have secondary properties in today's world, they are going to be brought up to the current property tax basis when anyone inherits them, child or not. Your primary residence, though, is still subject to being changed if either the child doesn't want it as their primary, or if you gift a home equally to multiple children, and let's say 2 out of the 3 don't want it, now 2/3 of that property can be reassessed and brought up to the current basis. So what is the good news in all of this? There is language that we can put in your revocable trust that essentially gives a child the first right to decide, do they want to live in it or not? And by doing that, you're essentially allowing them to purchase the estate or purchase the residence from your estate. What that means is they have to compensate their siblings, but they can then keep the full property tax basis if that is what they choose to do. Again, there is often a lot of discussion that comes into this, and so this can seem overwhelming, and we are going through it relatively quickly. So if you are concerned about how do I allow my kids or my homes to keep their property taxes, absolutely come and talk to us. So now let's turn to legacy. So this is something that not only here at Koppenbarger do we take very seriously, but you also heard Charles speak about it. And that is because your financial legacy can often be a very large part of what you want to focus on when you are looking at, how do I leave this legacy? But financial legacies are not the only thing you can leave. A lot of our clients, they either don't know where to start when it comes to legacy, or one of the things I've definitely heard, and it always makes me a little sad, is, well, I don't have that much money, so it doesn't really matter what my legacy is. That is not true at all. There is an emotional legacy. You can leave your morals and values. For me, it was actually receiving recipes from my grandma when she passed away, some of which had been handed down for generations. So your legacy can come in so many different forms, and not only can your estate plan or financial plan account for it, but we can give you other ideas and ways to leave legacies beyond that. So your financial legacy is more straightforward. This is through your estate plan and your financial plan. We can absolutely make sure the money is kept in your pocket, in your family's pockets. That way it's not just being eaten up by the government. So the financial legacy is something we address almost every single day with our clients. It's again this emotional legacy that is often overlooked, or at least not considered in the same way. Like I mentioned, for me, it was receiving recipes after my grandma passed. And there are ways that you can leave those things to people within your trust or through separate letters. A lot of people think, well, I don't want anything of my mom's because I don't really care. I have my mom. The second your mom passes, though, all of a sudden those recipes or that necklace she always wore, or the chair that you remember her reading to your child in, those things all of a sudden get a significant emotional attachment that cannot be taken lightly. And so these are things we try to encourage people to pre-plan for as much as possible, not only to ensure that that emotional legacy is there, but also to limit any fighting over things once you are gone. So again, this is something that even within your estate plan and even your financial plan, you can start addressing now. We absolutely believe your legacy matters. Here at Kopp & Barger in particular, we have a lot of family units within our own firm, and then they have their families outside of the firm. The two people in the middle, the two adults, are actually brother and sister. And so we have brother sisters here. We have nieces and their aunts. We have fathers and sons. I mean, we have family within our firm. And so we absolutely believe that your legacy matters because we see how valuable that legacy is to our own people. And so if you have any questions on how can you leave a legacy or where do I start, that is something we're happy to help you address. So if you're also wondering, who should I talk to about this? Pretty much anyone can benefit from speaking about estate planning or financial planning. There is frankly no one in this world who could not benefit in one way or another from each side of what we do. And the reason is there is so much information and you need someone who can break it down for you and make it tangible for your situation. It's really important to work with not only an estate planner who understands the financial side, but a financial advisor who understands the estate side. The estate planners that don't know how the financial piece works or are unwilling to work with your financial advisor, they're going to be more limited in what they can do and they may miss things. And that is the exact same in the reverse. Financial planners who are unwilling to work with your estate planner are often going to then miss things and potentially do a disservice to you. And so you need both parties to understand trusts, taxes, specialized planning, and just frankly be able to communicate with each other. So we are here to help you. So if you want to get in contact with Kopp & Barger because you have any questions, or if you need to get in contact with Lifestyle, you can reach out to us directly. I hope you enjoyed the information today. I know it was a lot, but we really appreciate you taking the time with us. I'm going to just check the Q&A really quickly. And if you have any last minute questions, please feel free to put them in the chat. All right, we've just got one question, but I'll answer that privately. But again, if you guys need anything from us, we are here to help you. Please give us a call if you have any questions. And thank you again for being with us today.
Thank you.